Hello. Welcome to the podcast today. This is Ralph's Law, where justice reigns. All right, this is just, it's another video. I'm trying to complete the video on one of my litigation series that I had on cross-examination. I've actually had a lot of people reach out to me and they wanted me to just finish it up. So that's what I'm trying to do today, okay? So we've pretty much gone through the whole thing about cross-examination. And we've talked about the fact that you, as an attorney, you can actually have a case that's not going so well. But if you do a very solid cross-examination, you can actually turn the whole thing around. So it's just a few reminders, on the stuff that you're supposed to do. The do's and don'ts of a cross-examination for you to get the best outcome for your client. Whoa, excuse me. Whoa. Okay, so yeah. So you just have to think about that, and that's what it's all about. So we've already talked about most of those things, You have to be brief in your cross-examination. Brief and concise, okay? One of the mistakes that I see some attorneys making is they ask a lot of questions. No compound questions. All right? One fact per question. That's how you do it. One fact per question. Remember, you're trying to control the whole situation. You're not really trying to give the client, the testifying witness, some kind of opportunity to explain stuff or to run the show. If you will. So the game is you, the attorney, you're the cross-examiner. As I said before, the other person is the witness is the examinee, the person that's been cross-examined. You run the show, and you have to make it basically actually has to be your way, so you have to control the whole situation. So cross-examination is not a situation where attorneys ask about it. Okay, put it this way. It's not a democracy. It is a benevolent dictatorship. Yeah, it's a benevolent dictatorship where you control the whole situation. And you use leading questions to tell the witness, to pretty much put certain words in the mind of in the mouth of the witness, and then you expect a response that's a yes or no. That's it. Do not give the witness the opportunity to explain a whole lot of stuff, because if they have to do that, they may surprise you, and that's the whole thing. Sometimes some attorneys don't get this. The witness might actually come up with a very beautiful explanation of a situation, and that will literally torpedo your case, okay? So don't do that. That's cross-examination, okay? So be brief. Use short words, short, concise questions. Also, avoid legalese. Don't use all the legal, the words that we all know, like as attorneys, the legal jargon, don't use all that. Use plain words, you guys know I'm an attorney. I'm also a law professor, and in the class that I teach advanced legal writing, and sometimes you actually have to understand, you have to determine who is your target audience, okay? So if you're trying to talk to the jury, you can use some legalese, you can use all these fancy legal words, but if it's not making sense to the jurors, the members of the jury, you're not scoring points, okay, because they're not going to try to figure that out. So if it's a bench trial, whatever, you can use some legal words, because at least the judge knows the words that you're using. The judge used to be an attorney. But when you're dealing with the jury, you have to think about it and try to use plain, good old, just basic words, okay? Just, put it where, I think somebody said put it where the chickens can get it, or some crazy stuff like that, but keep it simple. Kids, keep it simple. That's all you gotta do. Don't use the fancy legal words. I know, some of you want to do all this stuff, but don't do that, okay? one fact per question. Don't do compound questions. Don't mix up a whole lot of stuff in one question. One fact per question. Okay. And as we've already said, don't quarrel with the testifying witness, and try to, as much as possible, listen. Okay, you listen to what the witness is actually saying, because sometimes we make this mistake of just talking without listening. And I think, as I said in the other videos, communication 101, you say something and then you listen. You have to have listening skills, because that's why the good Lord gave us 2 ears and just 1 mouth. At some point you got to shut up and listen. All right? And that's what I'm trying to say. Sometimes as attorneys it's kind of hard for us to do, so I'm here. Uncle Ralph is here to tell you to listen. Sometimes you ask a question of a witness, pause and listen. That's it. This is Ralph's Law, where justice reigns. If you haven't done so already, subscribe, like, comment, and share. All right. And what we try to do in this podcast is, we keep things real. All right. And this actually is supposed to be helpful to other people. It doesn't have to be just for attorneys. Sometimes it's kind of like, I guess you can call it infotainment. Once in a while, when I'm in the mood, I bring in some kind of entertainment. But, basically, I'm all about politics and the law. I'm an attorney and I'm a law professor. So, sometimes I kind of get, I get a little wonky sometimes when it comes to the law. But bear with me. It's going to be okay. I try to keep it very, just basic, where, everybody's going to get it and everybody's going to have fun, okay? Ralph's Law, where justice reigns, okay? So that's the whole thing about cross-examination. So look at cross-examination in this way. Have your fingers on the trigger, but hold your fire. All right? And this is what a lot of attorneys don't understand, okay? Get the questions, be able to get all the responses that you want from the testifying witness, but don't go into your big finish. Don't do that. Reserve that for your closing. And that's the whole thing. Some people don't get this. Have your fingers on the trigger, but hold your fire. Don't do it. Don't go all out. Reserve that for the closing. Have the client, have the testifying witness where you want him or her. Have the jurors kind of think about the whole situation. At that point, the jurors are already making their own conclusions or whatever, or at least making their own inferences. Hold your fire. It will be beautiful and fantastic when you put the whole thing together in your closing arguments. Okay, so because the tips that I'm trying to give is what's called it's kind of known as a destructive cross-examination. That's what it is. Destructive cross-examination. In fact, it's actually silently destructive, and it's not. A lot of attorneys don't even know, don't understand how this is done. A silently destructive cross-examination. Set the person up, set the witness up where things are gonna blow up, but hold your fire. You remember, you have your fingers on the trigger, but hold your fire, and at the right time, boom, you will change the whole situation, preferably at your closing arguments. Okay, and this is what separates certain attorneys from certain great attorneys. So that's what I'm trying to say. Just understand. If you can understand the whole thing, like how to pace yourself and figure out how to get to the right outcome for your clients, you will be an amazing litigator. Okay, so build up to that conclusion, build up to that gradually, earn the trust of the jurors, but hold your fire. Okay, it's very necessary because part of this whole process is about patience. It's about patience and actually getting the trust, creating trust. You want the jurors to ride with you. If you have a story to tell, if you have a narrative, you want the jurors to ride with you. They have to ride with you. They have to trust your story, and they have to feel like they're all, you guys are all part of the same, like you're all part of the same team. Okay, so if you have them in that way, you can do an excellent cross-examination and stop the whole thing just short of pulling the trigger. All right, so cross-examination, hold your fire. All right, and I'm gonna do another video on how you can make the whole thing better. I'm gonna do another video on your closing arguments. Okay, and I'll also do another video on voir dire. All right, yeah, I haven't done that already, but a lot of people want me to do that. But yeah, we'll get back to all that. Okay, I'm telling you, follow these simple steps and you're gonna be so great in trial practice, just being a litigator in a courtroom. What I'm trying to do is actually to get I want to get some attorneys, even if like experienced attorneys, new attorneys. I want to get your litigation practices to the next level. I want you to come into the courtroom and dominate. Okay, I want you to dominate, and I want you to just get the best outcomes for your clients. Doesn't matter who you're representing, even if you're working, like if you're working for the DA's office or if you're working for the public defender's office, I want you to dominate. Okay, if you're working for the people, it doesn't matter. I want you to get the best outcome for whoever you're trying to represent. Okay, it has to be zealous advocacy for whoever you're trying to represent. Get the best results. Get your your litigation abilities to the next level so that you can get very solid results. Okay, and that's what we're about in this show. All right, Ralph's Law, where justice reigns. I will keep on making videos to get people to the next level. Thanks very much for your time. I hope you had a fantastic day. I had a great day today. And I will see you soon. Peace.